From WBAY TV, coverage you can count on. Action 2 News at 10 starts now.
Good evening. Thanks for joining us tonight. Arrested and charged for drunk driving, but walking away with just a slap on the wrist.
Those are the kind of tips Target 2 has been receiving in the last few months, asking Target 2 investigates if and how that could happen in Northeast Wisconsin. Our Sarah Thompson started digging through the records and uncovered what judges, prosecutors, and even defense attorneys describe as stunning.
If pictures say 1,000 words, these dash cam videos tell it all. Watch this woman trying to complete standard field sobriety tests.
1, 2, 3.
Falling to the side and having problems standing on one leg. She's arrested in Wapaka County for first offense OWI. Court records show her blood alcohol level at .196, more than twice the legal limit. Yet when her case goes through Wapaka County Court, that OWI no longer exists. It's amended to a fine for inattentive driving. Same with this woman, who falls during her tests. She too is arrested for first offense OWI. But in court, it turns into fines and tickets for improper parking and inattentive driving. Then there's this man who has problems with his ABCs.
You want to start at A and go to Z? A, B, C, D, U, F, G, H, I, J, K, L, M, N, O, P. Okay. I'm sorry, but all right. It's been 20 years.
He had a BAC of .17. His OWI first charge is dismissed, and he's charged with endangering safety with use of a dangerous weapon. But it's not just first-time offenses. This man is stopped after a deputy says he swerved over the yellow line. Dashcam shows him swaying and nearly falling.
If I was sober, I could not walk this line.
He's arrested for third offense OWI. His blood alcohol level, a .16. But his end result after court, a misdemeanor charge of negligent operation of a motor vehicle and no record of an OWI. These are some of the 30 cases where Target 2 found drunk driving charges being reduced or completely dismissed, all in Wapaka County between 2010 and 2015. We started digging into this after emails and phone calls to Target 2 over the last 6 months asking if this could really happen. We filed open records requests for OWI arrest records from the State Hygiene Lab, one of the labs that tests blood in drunk driving cases. We searched online court records for the more than 500 names we received and quickly began finding the amended charges. We filed more requests for hundreds of pages of motions, amendments, and police reports in those cases. We found first, second, third, even a seventh offense OWI. There's also the man court records show in 7 years was arrested 3 separate times for OWI third offense. One of those came after hitting a parked beer delivery truck. All 3 times, his drunk driving charges were dismissed or reduced. The motion in one case saying the court is not convinced the defendant's ability was impaired. That time, his blood registered an alcohol content of .256. Target 2 found other motions written by the Wapaka County District Attorney's Office saying despite the vigorous prosecution of drunk driving offenses, the state feels it will not be able to prove to a jury the defendant was operating a motor vehicle under the influence. So we asked experts, including a former Brown County prosecutor and a standard field sobriety test instructor and police officer, to review the motions and police reports.
I conclude from my experience as a standard field sobriety instructor, a criminal justice instructor, and even as an expert witness in OWI cases, and as a practitioner, that the officers did everything that they were supposed to do consistent with their training.
So why were the charges reduced? Target 2 asked judges, both presiding and retired, current and former prosecutors, defense attorneys, and law enforcement if reducing charges is common. Of the 24 people we talked to, not one of them said this is a common practice. They used words like stunning, shocking, and embarrassing. The judges adding they've never signed off on one or can only recall it happening 1 or 2 times in their roughly 30 years on the bench. But Wisconsin law does allow it. A prosecutor can ask a judge in a written motion to amend or dismiss, but it can only be approved if the court finds it's consistent with the public's interest in deterring drunk driving. We asked Wapaka County District Attorney John Snyder why he would agree to the amendments in some of the specific cases we found, like that 7th offense one. He responded, quote, "I don't know." He would only talk to us by phone and declined an on-camera interview. We also asked him if 30 cases is a lot. Snyder said, considering how many people are arrested for drunk driving, he doesn't view it, quote, as a large number. So Target 2 checked other counties, submitting an open records request for Calumet County, closest in size to Wapaka. We didn't find a single OWI charge amended there in the 3 years of data we received. Brown County tells us its prosecutors refuse to amend drunk driving cases and can recall very few in rare exceptions where the facts warranted it. Dorr and Portage counties said the same thing. The defense attorney that handled many of these amended cases told Target 2 he's aggressive and looks for significant issues with the evidence or traffic stop, adding the compromise is not entered into lightly and it's up to a judge to make the final decision. The experts we spoke with say, in the eyes of public perception, it's hard to dismiss or amend OWI charges.
We need to create an environment that people believe if they drink and drive drunk, that they will be arrested. And this clearly sends a message to the contrary.
Two Wapaka County judges tell Target 2 they have to rely on the, quote, good faith of what prosecutors present to them in court, since judges are not allowed to be part of any negotiations between attorneys and prosecutors. One judge also saying he doesn't recall denying requests because he relies on the expertise of prosecutors. Wapaka County District Attorney John Snyder tells Target 2 he is ultimately responsible for all the cases going through his office and, quote, must have approved these amendments. We asked the Department of Justice for comment as well, but have not heard back. The officers making these arrests say they too are fed up. We also took our findings to one of the nation's largest anti-drunk driving advocacy groups. What happened when they saw the results tomorrow night.
And for more information on this extensive Target 2 investigation, head to WBAY.com.
Much more to come.